Something changed in American law that most drivers haven't even noticed yet. There was no nationwide alert, no emergency broadcast, no dramatic announcement telling people to pay attention before getting behind the wheel. But, quietly, inside a Supreme Court decision about gun rights, a shift happened that could affect one of the most common interactions between citizens and law enforcement in the United States: traffic stops. If you drive regularly, chances are you've experienced one. Maybe it was a minor speeding ticket, maybe a broken taillight, maybe just a warning. But here's the thing most people don't think about until the moment it happens. A traffic stop is not just a conversation on the side of the road. It's a legal encounter governed by very specific constitutional rules. And when the Supreme Court changed the way gun laws are interpreted, it also indirectly changed how those rules may apply during traffic stops. Before we get deeper into this, I want to ask you something honestly. If a police officer pulls you over tonight, would you know exactly what your legal responsibilities are if you have a firearm in the car? Would you know what you must say, what you don't have to say, and what the officer is legally allowed to do? Think about that for a moment, because many drivers believe they understand these rules, but when you actually look at the law, a lot of those assumptions turn out to be wrong. I want you to share your answer in the comments. Would you feel confident handling that situation, or would you be unsure what the law actually requires? Go ahead and tell me in the comments, and keep listening, because the Supreme Court's recent reasoning has made this issue even more important for drivers to understand. Let's start with something simple. Every traffic stop begins with the same basic principle under the Constitution. Police officers are allowed to stop a vehicle when they have reasonable suspicion that a traffic violation occurred. That could be speeding, running a red light, failing to signal, even something as small as a cracked taillight. Once the vehicle is stopped, the officer has the authority to investigate the reason for the stop. They can ask for your driver's license, your registration, your proof of insurance. They can run your information through their system to check for outstanding warrants or license issues. All of that has been considered standard procedure for decades, but where things become legally complicated is when the officer begins to suspect the presence of a weapon. For many years, courts have allowed officers to perform what's known as a protective frisk if they believe a person may be armed and dangerous. This comes from a long line of legal decisions designed to protect officer safety. The logic behind it is fairly straightforward. Traffic stops can be unpredictable. Officers don't know who they are approaching. They don't know whether the driver is calm, intoxicated, angry, or possibly involved in other crimes. Because of that uncertainty, the law allows officers limited actions to ensure their safety. However, there has always been an important condition. The officer must have a reasonable belief that the person may be armed and dangerous. That phrase matters a lot. It doesn't simply say armed. It says armed and dangerous. Now, this is where the Supreme Court's recent gun rights decision begins to change the legal conversation. In that ruling, the court made it clear that law-abiding citizens have a constitutional right to carry firearms in public for self-defense. That recognition matters in a practical way. If carrying a firearm in public is constitutionally protected, then the presence of a firearm cannot automatically be treated as suspicious behavior. Think about what that means during a traffic stop. In many states today, thousands or even millions of people legally carry firearms. Some have concealed carry permits. Others live in states with what's called constitutional carry, meaning no permit is required for eligible citizens. So when an officer approaches a vehicle, the possibility that the driver is armed may no longer indicate illegal activity. That changes the assumptions officers and courts have traditionally relied on. Years ago, if an officer suspected someone had a gun, that suspicion might strongly suggest a potential crime depending on the state's laws. Today, in many places, that same situation could simply mean the person is exercising a legal right. And that's why legal experts say the Supreme Court's decision quietly affects traffic stops. Because if being armed is not unusual or suspicious, then courts must reconsider how that fact influences police authority during encounters. This issue becomes even more complicated when we look at something called duty to inform laws. Some states require drivers to immediately inform police officers if they are carrying a firearm during a traffic stop. Other states do not require that disclosure unless the officer asks. And a few states have no requirement at all. This creates a situation where the rules change depending on where you are driving. Imagine someone driving across state lines during a road trip. In one state, they are legally required to tell the officer they are carrying a firearm. In the next state, that requirement disappears. If the driver doesn't know the difference, they could unintentionally violate the law. And unfortunately, misunderstandings during traffic stops can escalate quickly. Another important factor involves how officers decide whether they can search a vehicle. Under the Fourth Amendment, officers generally need probable cause to search a car without consent. Probable cause means there must be reasonable evidence suggesting a crime has occurred or that illegal items are present. However, there are exceptions. For example, if an officer sees illegal items in plain view, that can justify a search. If a driver gives consent, a search may also occur. But when firearms are involved, the situation becomes more sensitive, because firearms may be completely legal to possess. That means the presence of a gun does not automatically indicate criminal activity, and that's where the Supreme Court's reasoning comes into play again. If the Constitution protects the right to carry firearms in public, courts must be careful not to treat that right itself as suspicious behavior. In other words, the exercise of a constitutional right cannot automatically justify a search. At the same time, officer safety remains a legitimate concern. Courts will continue balancing those two ideas. On one hand, citizens have constitutional rights. On the other hand, officers must be able to protect themselves during unpredictable encounters. Finding that balance is not always easy. This is why many legal experts expect future court cases to address these issues more directly. Lower courts will eventually need to decide how the Supreme Court's reasoning applies to specific situations during traffic stops. Until those cases develop, the boundaries may remain somewhat uncertain. For drivers, the most important lesson is preparation. If you carry a firearm in your vehicle, you should understand the laws in your state and any state you plan to travel through. You should know whether your state requires you to inform officers during a traffic stop. You should know how firearms must be stored in a vehicle under state law, and you should understand that federal restrictions still apply in certain locations. Airports, federal buildings, and some government facilities have their own firearm rules that are separate from state laws. Another thing drivers often misunderstand is the concept of consent. During a traffic stop, an officer might ask if they can search your vehicle. Many people feel pressured to say yes because they think refusing will make them look suspicious. But legally, consent must be voluntary. If you do not want your vehicle searched, you have the right to decline. Of course, the officer may still proceed if they believe probable cause exists, but the decision to consent is ultimately yours. Understanding that distinction is important because once consent is given, it becomes much harder to challenge the legality of the search later. Another situation that sometimes surprises drivers involves passengers. If a passenger in the vehicle is carrying a firearm, their legal responsibilities may differ from the driver's. Depending on the state, the passenger may also have a duty to inform the officer, and if the firearm is stored in a shared area of the vehicle, questions about possession may arise. These situations highlight how complicated firearm laws can become during everyday encounters. That complexity is one reason why Supreme Court decisions often have ripple effects beyond the original case. When the court strengthens a constitutional right, it forces the legal system to reconsider how that right interacts with other laws. In this case, the right to carry firearms intersects with search and seizure rules during traffic stops. It intersects with officer safety policies, and it intersects with state laws that vary widely across the country. For drivers, the best approach is awareness. Know your state's laws. Stay calm during traffic stops. Keep your hands visible and follow the officer's instructions. If you are required to disclose that you are carrying a firearm, do so calmly and clearly. If you are not required to disclose, understand your rights, but also understand that the roadside is not the place to debate legal theories. Courts exist for that purpose. Traffic stops are brief encounters designed to resolve immediate issues. The Supreme Court's decision did not eliminate gun laws. It did not eliminate police authority during traffic stops. What it did do is reinforce the idea that carrying a firearm for self-defense can be a lawful exercise of a constitutional right. And when courts recognize a right like that, it changes how other laws must be interpreted. That's why some legal observers say the most important effects of Supreme Court decisions are sometimes the quiet ones, the parts that don't make the headlines. The subtle shifts in how everyday interactions are understood under the Constitution. For millions of drivers, traffic stops may become one of those areas where the effects of this ruling slowly unfold. Law enforcement agencies will continue adapting their training. Courts will continue clarifying how the law should be applied, and citizens will continue navigating their rights and responsibilities during encounters with police. Which brings us back to the question I asked earlier. If you were pulled over tonight, would you know exactly what the law requires if there's a firearm in your vehicle? Would you know whether you must inform the officer? Would you know what the officer is legally allowed to do next? Take a moment and think about that. Then share your answer in the comments. Because the reality is that many Americans drive every day without fully understanding how these laws work. And when constitutional rights, firearm regulations, and traffic stop procedures intersect, knowledge can make the difference between a routine stop and a serious legal problem. The Supreme Court may have quietly changed the legal landscape, but what drivers know or don't know about their rights will determine how that change plays out on the side of the road.